Welcome to my channel where we discuss everything about things politics, especially about the 2023 presidential election held in Nigeria on February 25, 2023, and the result announced on March 1st, 2023, and the result is being disputed in court. Now, you know that we have entered the final stage of the challenge of the election of President Bola Tinubu as the president of the country. Now, Peter Obi, in his final written address to the tribunal, Presidential Election Tribunal, he stated that the unchallenged forfeiture order, forfeiture order is evidence Tinubu was guilty of drug trafficking. That's what Peter Obi told the tribunal in his final written address. He informed the Election Petition Tribunal that the unchallenged order of the forfeiture meted out against the All Progressive Congress presidential candidate Bola Tinubu is evidence that he is guilty of drug trafficking in the United States. Obi made these remarks in his final written address to the tribunal holding at the Court of Appeal in Abuja. Obi wrote that through his lawyers, he wrote that the second respondent, that's Bola Tinubu, till date has not challenged the order of forfeiture made by the U.S. court. So Obi informed the tribunal to take note of this, that Tinubu has not challenged that order of forfeiture made by the U.S. order. And Obi stated the following. He stated that the unchallenged order of forfeiture made against Tinubu by the United States District Court, Northern District of Illinois, Eastern Division, in case number 93C 4483. The petitioner, that's Peter Obi's submission on this ground, is predicated on the decision of the United States District Court, Northern District of Illinois, Eastern Division, in case number 93C 4483, which ordered that the funds in the amount of $460,000 in account, the account number is 263226700, held by the Heritage Bank in the name of Bola Tinubu, represents the process of narcotic trafficking, or were involved in financial transactions in violation of 18 USC 1958 and 1956 and 1957. The decision encapsulated in the order is tendered as exhibit PA5 before the Honorable Courts. The above order made by the United States District Court was sequel to a settlement order of claim to funds held by Heritage Bank and Citibank, wherein Bola Tinubu, the second respondent, and others claimed ownership of the sums in the accounts. The second respondent, that's Bola Tinubu, till date has not challenged the order of forfeiture made by the U.S. court as shown above. He said that it is important to note, to underscore that the proceedings in exhibit PA5 above, that's forfeiture proceeding, the order was based among other things by the revelation findings in the affidavit of Kevin Moss, a special agent and investigator on financial crime, money laundering, and narcotic trafficking, inter alia, that interviews with investigators from the U.S. Customs Service disclosed that the address at 7504 S. Stewart Avenue is known as a drop-off point for packages from Nigeria that contain white heroin, and that in the application to open his account at the First Heritage Bank, Illinois, Chicago, Tinubu stated that his address was 7504 South Stewart, Chicago, Illinois. So you can see that this address, his address tallied with the address that they said they dropped. cocaine as a drop point of cocaine. So his address in the bank is the same address that investigators found out that that's where they used to drop bags of cocaine when it lands from Nigeria. Now, continuing, Peter Obi stated that it is submitted that one of the provisions of the law the court held was violated was 18 USC 1956, which outlaws money laundering. Now, Peter Obi now is citing authorities. In Gabriel Daudu and Federal Government of Nigeria, 2008, it was held that money laundering is a global scourge that affects countries worldwide, Nigeria not being an exception. It has been described as the washing of illegitimate money in a bid to make it appear clean or legitimate. It involves the process of transforming the proceeds of crime into ostensibly legitimate money or other assets. This honorable court, in several other cases, including Ojo Zokalo versus Federal Republic of Nigeria and others, rightly took a swipe against money laundering and adopted with approval the definition of the phrase in the book, money laundering, Butterworth's Nexus 2003 at page 3, paragraph 1.3. Varied means used by criminals to conceal the origin of their activities. The term laundering is used because these techniques are intended to turn dirty money into clean money, but laundering is not confined to cash. In Okewu and Federal Republic of Nigeria, 2023, the court equally upheld that narcotic trafficking or dealing in narcotic drugs are prohibited by law. It is important to submit that in Abuja versus Federal Government of Nigeria, it was held that the word forfeiture means divestiture of property without compensation, the loss of a right, privilege, or property because of a crime, breach of obligation, or neglect of duty. It follows that title in those assets and properties forfeited is ostensibly transferred to another, such as the government. You can see Black Dictionary, 9th edition, page 722. My noble lords, Peter Obi and his lawyer continued, the provisions of Section 137 of the 1999 Constitution is clear, explicit, unambiguous, and clearly provided as follows. A person shall not be qualified for election to the office of the president if he is under a sentence of death imposed by any competent court of law or tribunal in Nigeria, or a sentence of imprisonment or fine for any offense involving dishonesty or fraud by whatsoever name called, or for any offense imposed on him by any court or tribunal, or substituted by a competent authority for any other sentence imposed on him by such a court or tribunal. We respectfully invite your lordships to uphold that the above subsection, by the use of the word or, in the several instances, envisage a disjunctive meaning and interpretation for those several instances. As such, the ordinary plain meaning of the subsection is that a person shall not be qualified for the office of the president if, among other things, he is under a fine for any offense involving dishonest or fraud by whatever name called, of any offense imposed on him by any court or tribunal. It is submitted that the order of forfeiture made against Tinubu by the United States Court, as reproduced above, constitutes a fine, and it is in respect of an offense involving dishonest or fraud by a court. With due respect, the submissions on page 22 to 25 of the written address are incorrect and do not reflect the actual position of the law. It submitted that the misconception of the second and third respondents to the effect that a conviction must exist before a person will be disqualified from contesting for the office of the president, and which said misconception stems from their unfortunate albeit misguided reliance on section 137E of the 1999 Constitution. The petitioner's case is not based on Section 1371E, but rather on the provisions of Section 137 of the 1999 Constitution. The second and third respondents further attempt to discredit the evidence of PW1 by stating that he visited the United States once in 2003 is of no moment. SBPA5 are documentary evidence which is certified, sealed, notarized, and authenticated by a United States court which issued it. SBPA5 fully comply with the provisions of Section 106HI of the Evidence Act 2011, and it is in conformity with the authoritative pronouncement of this honorable court in MV Delos versus Ocean Steamship Limited. This court interpreted a similar provision and held that a party who intends to rely on the judgment of a foreign court must comply with either of two options, namely as follows: by sealing the judgment with the seal of foreign court, or by a copy certified by the legal keeper with a certificate of a notary public, or of a counsel or diplomatic agent stating that the copy is duly certified by the officer. That is all the law requires, my lords. Continuing, Peter Obi's lawyer said, in MVD Delos Sopra, the court further held on pages 108 to 109 that under the Nigerian Evidence Act, if the foreign judgment exhibit FA3, but in the instant petition is exhibit PA5, had been sealed with the seal of the New York court, or had been satisfied by it, it would have been admissible in evidence. In this case, the U.S. court proceeding tendered have been so sealed, certified, hence they are admissible in evidence. In the instant case, therefore, your lordship are urged to uphold that SB PA5 tendered in this petition is sealed and certified and thereby admissible. It is instructive to also submit that in MVD Delos Sopra, the court went further to hold that a certified copy of foreign judgment, such as Exhibit PA5, is capable of operating as estoppel per rem judicantem once pleaded and tendered in evidence. We urge your lordships to disregard the arguments of the second and third respondent to the fact that Exhibit PA5 has not been registered in Nigeria, as according to them, such registration is required by the provisions of Section 3 of the Reciprocal Enforcement of Foreign Judgments Ordinance and Foreign Judgment Reciprocal Enforcement Act. Respectfully, SB PA5 is neither a money judgment nor are the petitioners by this proceeding seeking to enforce any money judgment against Bola Tinubu, nor is this petition intended for the recovery of a sum payable under a foreign judgment. Accordingly, Section 3 of the Reciprocal Enforcement of Foreign Judgment Ordinance and Foreign Judgment Reciprocal Enforcement Act, heavily relied on by the second and third respondent, are completely inapplicable to the instant petition. The second and third respondent have also placed reliance on Article 54(1)(c) of the United Nations Convention Against Corruption, which talks merely of member states providing mutual legal assistance concerning property acquired through or involved in the commission of an offense established in accordance with the convention. The question whether Exhibit PAS tendered by the petitioners here has anything to do with mutual assistance. Indeed, the head note of Article 54 is this: the mechanism for recovery of property through international cooperation in confiscation. With very great respect, above Article 54 United Nations Convention Against Corruption is very relevant in this petition. Respectfully, my noble lords, the cardinal question is whether a civil forfeiture under U.S. law, as ordered in Exhibit PA5, can be equated to a fine as used in Section 1371D of the 1999 Constitution. The answer on settled case law in the US and legal literature is in the affirmative. In the well-known case of Austin versus United States, 1993, the US Supreme Court unanimously held that civil forfeiture order ordered in an in rem civil action is a fine and is a punishment, regardless that it did follow from criminal conviction. The court relied on several authorities and held, among other things, that forfeit is the word Congress used for fine. Dictionaries of the time confirms that fine was understood to include forfeiture and vice versa. In the recent case of Thames versus Indiana, appeal number 171091, decided by U.S. Supreme Court in February 20th, 2019, the state of the state of Indiana, seized Thames Land Rover SUV. It had filed civil forfeiture proceedings, claiming that the SUV had been used to transport heroin. The question before the Supreme Court was whether the cost of the vehicle vis-a-vis the fine that would be imposed upon Tim's conviction violated the U.S. Eighth Amendment's excessive clause provision of the U.S. Constitution. Inevitably, this amounted to equating civil forfeiture to a fine. The U.S. Supreme Court said this in express terms. Justice Ginsburg, who delivered the lead opinion of that court, to which there was no single dissent, in questioning the civil forfeiture as being excessive and therefore unconstitutional, held entirely as follows. For a good reason, the protection against fines has been a rampant shield throughout Anglo-American history. Exorbitant tolls undermine other constitutional liberties. Excessive fines can be used, for example, to retaliate against or chill the speech of political enemies, as the Staff's critic learned several centuries ago. C. Brown and Ferris, 492 U.S. at 267. Even absent a political motive, fines may be employed in a measure out of accord with the penal goals of retribution and deterrence, for fines are a source of revenue, while other forms of punishment cost a state money. Hamelin versus Michigan, 501 U.S. 957. Opinion of Scalia J., the Justice of the Supreme Court. It makes sense to scrutinize governmental action more closely when the state stands to benefit. This concern is scarcely hypothetical. See brief for American Civil Liberties Union et al. As Amici Curie. Perhaps because they are politically easier to impose than generally applicable taxes. State and local governments nationwide increasingly depend heavily on fines and fees as a source of revenue. Now, these are now continue again. He said, in short, the historical and logical case for concluding that the 14th Amendment incorporates the excessive fine clause is overwhelming. Clause is protection against excessive punitive economic sanction by the clause is to repeat both fundamental to our scheme of ordered liberty and deeply rooted in this nation's history and tradition. McDonald 561 US at 767 internal quotation marks. Now, he said in the case of Austin versus United States, however, this court held that civil in rem forfeiture fall within the clause's protection when they are at least partially punitive. But when a Bill of Rights protection is incorporated, the protection applies identically with both the federal government and the states. According to Prevail, Indiana must persuade us either to overrule our decision in Austin or to hold that in light of Austin. The excessive fine clause is not incorporated because the clause's application to civil in realm forfeitures is neither fundamental nor deeply rooted. The first argument is not properly before us, and the second misapprehends the nature of our incorporation. Now, I think they are doing all these things to show that even though it's a civil forfeiture, Tinubu committed a crime. That is what the lawyers are driving at. They are using United States to show that he committed a crime. It may be civil forfeiture, but it's a crime. It's continuing. They said a civil forfeiture in US amount to a fine or punitive economic sanction, and it's also at least partially punitive against the person whose property is affected. Why did Tim challenge the forfeiture proceeding if he was not to be personally affected? Can it be honestly argued that Tinubu's herein did not suffer economic sanction when he forfeited $460,000 to the United States government? It is submitted that the decision of the U.S. Supreme Court above ranks superior to evidence called by the respondents and the text written by T.S. Greenberg et al. Entitled A Good Practice Guide for Non-Conviction Based Asset Forfeiture, World Bank 2009-13, cited by the second and third respondents on page 24 to 25 of their final written address. Respectfully, my lords, under the Nigerian law, the word fine used in section 1371D of the 1999 Constitution as amended also contemplates an order of forfeiture made against the second respondent, that's Tinubu. Under the Administration of Criminal Justice Act 2015, the interpretation section defined fine as includes any pecuniary forfeiture or pecuniary compensation payable under this act. Penalty includes any pecuniary fine, cost, forfeiture, or compensation recoverable under an order. In AG Bender State versus Agbofodo, 1999, the Supreme Court held entirely forfeiture is an action of forfeiting something or being forfeited. It is a penalty, a forfeit, a fine, a mulct. It is anonymous with fine, penalty, damage, confiscation, sequestration, and amassment. See also the judgment of Ogwebu JSC at page 501 to 502 and the JSC at page 507. A similar definition of the word forfeiture was adopted by this honorable court in Bashir versus Federal Government of Nigeria in 2016, in the celebrated case of Abacha versus Federal Government of Nigeria in 2014. Arewola JSC, now Chief Justice of Nigeria, referred to other authorities on the point and rightly concluded that these definitions leave no doubt that forfeiture is a sanction, a fine by the court. It is penal and criminal in nature. You can see this Supreme Court, the present Chief Justice of Nigeria in 2007, he confirmed that forfeiture is a sanction, is a fine by the court. So how would Tinubu escape from this? Let's go. It is submitted that by the express meaning and intent of section 1371D of the 1999 Constitution, a person who, even though not convicted, have forfeited property on account of criminal conduct should not aspire to or be allowed to occupy the exalted office of President of Nigeria. That is why the word "or" is used twice in section 1371D of the Constitution, meaning it carries a disjunctive meaning to separate persons convicted from persons who, even though not sentenced, are affected by an order of a fine imposed by a court, like the second respondent in this petition. In other words, the affected person in this case, Bola Tinubu, needed not to have been convicted before the provision of that paragraph will come into effect. The United States District Court, number one, the District of Illinois, which made the order of fine against Tinubu, comes with the category of the term any court provided in section 137 of the Constitution of Federal Republic of Nigeria, 1999, as amended, with the tenure of the section where it was intended to apply to Nigerian court. That was provided for expressly before he proceeded with the disjunctive term by operation of the word or to after that provided for the applicability of any court. The Constitution does not define the term court to justify a restrictive interpretation of the term to the courts provided for under the Constitution of the Federal Republic of Nigeria, 1999, as amended. Therefore, we submit that the reasonable conclusion is that courts are not limited to Nigeria, and Section 137D intends to apply to any courts, whether Nigerian or otherwise. We submit further that the provisions of Section 1371D merely require that the candidate is under the fine imposed. In the instant case, the respondent's admission to ownership of the bank account brings him under the fine imposed. The action being one in rem against fund held in his personal account is a lien for which the resulting liability is strictly personal. The contention that the fine was imposed against the bank account alone is puerile and amount to a moot distinction without a difference. Now, this area is where they settle the case that where they claim that what was indicted was Tinubu's bank account, not Tinubu himself. This presentation Peter Obi has shown that you cannot differentiate Tinubu from his bank account. He is one and the same with his bank account. Continue. The court, they said this court settled the location where liability lies in action in AW Nigeria Limited versus Super Maritime, when it held that on foundation of action in rem, the foundation of an action in rem is the lien resulting from the personal liability of the owner of the race. Having regard to the foregoing definitions of money laundering, there is no doubt that its nature and character clearly involve dishonesty on the part of the persons who engage in money laundering, as in the case of Bola Tinubu. In defense, the second to the third respondent relies on RW2, a witness that is already discredited for disowning on oath a part of the document he tendered in evidence. To defend the issue of the disqualification of Tinubu to have contested the presidential election, the R2 identified as a purported expert in U.S. law. Under cross-examination by the fourth respondent, he stated that he's an attorney in the U.S. He tendered American Bar Association New York Bar membership card as his bit RA28. Under cross-examination on behalf of the petitioner, he admitted that he did not tender any license to practice in the state of New York. He claimed that he has a license to practice federal law across the United States. With respect, that is a fictional claim. Under cross-examination before the petitioners, here they are talking about the Senate leader, Opayemi, who came to as a witness for Tinubu, claiming that he can practice law in the United States, and they were able to prove to him that he lied. Under cross-examination on behalf of the petitioners, the RW1, that's Opayemi, stated that the American court relied on American law section 981 dealing with civil forfeiture. This statement is embarrassing and betrayed his claim of being knowledgeable in American law. His claim is grossly untrue, ludicrous, and deeply misconceived. He further stated that the U.S. judgment is not money judgment. This contradicts the claim in his deposition that the judgment is registrable in Nigeria pursuant to Foreign Judgments Reciprocal Enforcement Act. Only money judgments are registrable in Nigeria. It is therefore submitted that the second respondent, against whom an order of forfeiture was made in Exhibit PA5, which said order of forfeiture has been shown to be the same as a fine, is within the meaning and intent of Section 1371D of the 1999 Constitution as amended, not qualified to contest the presidential election held on February 25, 2023. Your Lordship are on this ground urged to uphold the petitioner's claims seeking for the disqualification of the second respondent. that is Bola Ahmed Tinubu. Now, this is the case, watertight case that Peter Obi and his lawyers have presented in their final written address to show that Tinubu should be disqualified. And many of the things they said here, if you have been following my channel, I have stated it. Some of the things they cited here, I've cited it, including that Arewola in 2014, his definition of forfeiture is exactly the trap that Tinubu's own fall into, and he can't escape it. Arewola and the Supreme Court cannot come and redefine forfeiture different from what happened to Bola Ahmed Tinubu. Because with the definition of forfeiture that Arewola, Chief Justice of Nigeria now, he gave in 2014, in the case of Abuja versus the federal government, cannot be different from that of Bola Ahmed Tinubu in 2023. But we keep our fingers crossed, because at the end of the day, whatever the justices say is the final say. And all of us, we can only scratch our head and complain if they didn't follow their own judgment. Because what Peter Obi and his lawyer have done is to use their own judgment to put before them. You have seen many judgments they were citing were Supreme Court justices, Supreme Court judgment, putting it before them. Even though the thing is at the appeal court now, but they are putting in their past judgment, their past judgment before them. Are they going to do anything different now? Because it involves Bola Ahmed Tinubu, or because the president have already been sworn in? We are keeping our fingers crossed. We can't say what will be their final decision. But the truth of the matter remains that Peter Obi and his lawyers, they have shown that they did a good job in encircling Tinubu in the case of his drug-related indictment and forfeiture of $460,000 to the United States government. And they gave you the definition of what a fine means in US, what civil forfeiture means in US, what it means in Nigeria, and they are no different. So how will Tinubu escape? Only God knows. So let us keep our fingers crossed and see what the Supreme Court or what the appeal court will say in the first instance before we move to the Supreme Court. Because like I keep saying, this matter will end up in the Supreme Court at the end of the day. Whatever the outcome of Presidential Election Petition Court, if Tinubu is sacked by the Presidential Election Petition Court, Tinubu will appeal at the Supreme Court. If Peter Obi and Atiku Abubakar get a negative result, verdict, they will go to the Supreme Court. But the truth of the matter remains, Peter Obi and his lawyers have given a good evidence, citing sources that even the Supreme Court, their previous rulings, are they going to deviate from that now? The world is watching. Thank you for watching this video. And if you are new to my channel, you have not yet subscribed to my channel, please subscribe to my channel, hit the subscription button, hit the notification bell. When you subscribe to my channel and hit the notification bell, anytime I have a new video, you will be among the first to know. And please don't forget to like this video, because when you like it, Google will rank it high and recommend it for more people. God bless you and yours.